Thank you, Mr. President. Mr. President, I rise today to follow on some of the comments that were made by my colleagues who have come to the floor to talk about the nomination of Judge Sotomayor to the Supreme Court of the United States. And I would start by saying, Mr. President, that any confirmation the Senate considers is important, but none more so than a lifetime appointment to the most distinguished judicial office in our nation. Now that the President has nominated Judge Sotomayor, it is the Senate's job to give advice and consent. As Alexander Hamilton told the Constitutional Convention, senators, and I quote, cannot themselves choose. They can only ratify or reject the choice of the President, end quote. Mr. President, I take this role very seriously, as do all of my Senate colleagues. In fact, just 3.5 years ago, on this very floor, one of our colleagues in the Senate at the time rose and gave the following views on a then-pending Supreme Court nomination. And I want to quote for you, Mr. President, what he said. He said, there are some who believe that the President, having won the election, should have complete authority to appoint his nominee, and the Senate should only examine whether the justice is intellectually capable and an all-around good person. That once you get beyond intellect and personal character, there should be no further question as to whether the judge should be confirmed. I disagree with this view. I believe firmly that the Constitution calls for the Senate to advise and consent. I believe it calls for meaningful advice and consent, and that includes an examination of the judge's philosophy, ideology, and record. End quote. Mr. President, the senator who made those remarks was then Senator Obama. He spoke these words in January of 2006 on this floor when the Senate was debating the confirmation of now Supreme Court Justice Samuel Alito. And I, like the President, believe that it is the Senate's constitutional duty to thoroughly review all nominees to the federal bench, especially those who will have a lifetime appointment to the highest court in our nation. This review should be thorough and fair and cover a nominee's background, judicial record, and adherence to the Constitution. This is especially true with the voluminous judicial record that Judge Sotomayor has compiled with over 3,600 federal district and appellate level decisions. The Senate must also work to ensure that the nominee will decide cases based upon the bedrock rule of law as opposed to their own personal feelings and political views. As part of this confirmation process, I had the opportunity this morning to meet personally with Judge Sotomayor. Like many in this body, I agree that Judge Sotomayor has an impressive background as well as a compelling personal story. But Mr. President, what we have to do is we have to examine and look at her record when it comes to her understanding of the Constitution, especially as it relates to the Second Amendment right to bear arms. That's an area where I have significant concerns. While sitting on the Second Circuit Court of Appeals, Judge Sotomayor has consistently advanced a narrow view of the Second Amendment and done so with little explanation or reasoning. For example, twice Judge Sotomayor has ruled that the Second Amendment is not a, quote, fundamental right, end quote. The first time she did so with a one-sentence footnote, and most recently, it was simply stated as fact without any explanation or reasoning being provided. Judge Sotomayor's views on whether the Second Amendment right to bear arms is a fundamental right are so important because the Supreme Court has made this determination a key element in deciding whether to apply parts of the Bill of Rights, such as the Second Amendment, to state and local governments. This question, also known as incorporation, is likely to be the next Second Amendment issue the Supreme Court will consider because the Circuit Court of Appeals are split, and the Supreme Court specifically noted that they were not deciding this issue in the landmark District of Columbia versus Heller decision, which was decided last year. What is most troubling to me, though, is that these Second Amendment cases point out a trend that legal experts have expressed about Judge Sotomayor, that she has a record of avoiding or casually dismissing difficult and important constitutional issues. It doesn't take an attorney to notice that Judge Sotomayor's discussion of incorporation, a challenging and constitutionally significant issue, consists of just a few paragraphs. In contrast, the opinions for both the Ninth Circuit and the Seventh Circuit discuss the issue at length, and in doing so give this important issue the attention and analysis that it deserves. Now, while I understand that writing styles can and do vary, even in the writing of judicial opinions, I am still concerned about the apparent lack of thoughtfulness and thorough reasoning in her decisions. Another example of a Judge Sotomayor opinion that appears to be unnecessarily short and inadequately reasoned is the Ricci versus De Stefano case, or more popularly known as the New Haven firefighter promotion case. In this case, a 3-judge panel, which included Judge Sotomayor, published an unusually short and unsigned opinion that simply adopted the lower court's ruling without adding any original analysis. Even one of Judge Sotomayor's own mentors, Judge Jose Cabranes, commented that the Ricci opinion, and I quote, contains no reference whatsoever to the constitutional claims at the core of this case, and that the perfunctory disposition of the case rests uneasily with the weighty issues that are presented by this appeal, end quote. Mr. President, without careful reasoning being provided, critics and supporters alike have been left to wonder on what basis these decisions have been made. And I am left with concerns about these rulings and whether or not they are based upon personal views and feelings rather than the rule of law. Mr. President, my short meeting that I had with Judge Sotomayor this morning did not provide either of us with enough time to address these issues and these concerns at length. And that is why, like many of my colleagues, I will be monitoring closely the confirmation hearings that are set to occur next month. During those hearings, it is my hope that the members of the Judiciary Committee take the necessary time to explore and thoroughly examine her positions and legal reasoning, especially on the Second Amendment, in greater detail. And so, Mr. President, I, like many of my colleagues, are anxious to see this process move forward. We also understand the weight that is attached to the constitutional role of the Senate when it comes to advise and consent, and that when you consider a lifetime appointment to the highest court in the land, that you better make sure that you do your homework, that you thoroughly and completely and fairly examine that record. And I hope that the Judiciary Committee, and I know that they will conduct this in a way that's consistent with the tone that I believe ought to be a part of this. It ought to be a civil discussion, but it also needs to be thorough, Mr. President, because we are talking about a lifetime appointment to the Supreme Court. And whoever ends up on that court is going to be faced with a great many issues, all of which have lasting consequence for this great republic. In my view, it's important that we have judges who are put on the Supreme Court who understand that the role of the judiciary in our democracy is not to take sides. It is to be the referee. It is to be the umpire. It is to be someone who applies the Constitution, the laws of this land, fairly to the facts in front of them, to the cases that they will hear. And I would certainly hope that as we have an opportunity to more thoroughly review the record of this nominee, that the members of the Judiciary Committee and all the members of the United States Senate will take very seriously that responsibility. But that will be the criteria, Mr. President, and the filter by which I look at this nominee is whether or not, in my view, she exercises an appropriate level of judicial restraint, does not view the role of a judge in our judiciary system in this country to be that of an activist, of someone who expresses personal feelings or tries to advance some particular political agenda, but someone who, in terms of their philosophy and their temperament, is committed to that fundamental principle of judicial restraint, which I think is a hallmark of our democracy and has been for the past 2 centuries.